Hi, this is Bennett Kelly. Thanks for listening to Cyber Law and Business Report. Before you take a recess to hear the latest internet law news and commentary, you are hereby ordered to download the webmasterradio.fm mobile app for iPhone and Android. Okay, maybe not ordered, but why not? You can listen live to my show and all our show hosts every day on our live stream or download past episodes with ease. So download the webmasterradio.fm mobile app in the iTunes Store or in the Google Play Store. It's an open and shut case.
All rise.
Welcome to the Cyber Law and Business Report. Get the top story on the hot button internet legal topics of the day. This is your home for the latest on internet law and policy. Hear the latest net trends impacting business and have your questions answered right here. This is the Cyber Law and Business Report. Now, please welcome your host, the founder of the Internet Law Center, Bennett Kelly.
Good morning. This is Bennett Kelly. Welcome to another edition of Cyber Law Business Report, broadcast live from the Internet Law Center in Santa Monica, California, the heart of Silicon Beach. We have a big episode for you today. There's a lot been going on out here in California. Governor Brown has signed a flurry of legislation dealing with privacy and data security, and so we're going to be talking about that. And we have with us Harriet Pearson from Hogan Lovell, and who's actually calling us. We'll be talking to her. She's actually attending the International Association of Privacy Professionals Privacy Academy up in Seattle. And but Harriet has a vast experience in privacy. She was the Vice President and Security Counsel and Chief Privacy Officer at IBM for many years, and co-chairs Georgetown University Cybersecurity Law Institute. She's also involved in some major cases involving data breaches, and most notably a Wyndham Hotels challenge to the FTC's authority to regulate data breaches under the FTC Act. So luckily we have Harriet, who's going to kind of help us navigate through this flurry of legislation coming out of Sacramento within Governor Brown's signature pen. And without further ado, Harriet, are you with us?
Hello, this is Harriet.
Hi, Harriet. Thanks for joining us. And so we've had quite an interesting month, it seems, coming out of Sacramento in terms of both privacy and data security. We've had Governor Brown has now signed 3 major bills, one dealing with the Do Not Track, another one dealing with children's privacy, and then a third is a data breach bill. And then, of course, there also he signed up the revenge porn bill also, I believe, yesterday. So let's start with the Do Not Track bill. And what is your take on this, and what do you think the ramifications will be?
Sure, and it's worth noting that the 3 bills that were signed within the last couple of weeks are actually 3 out of 14 bills that were introduced in the last year. And some are saying that California has become the Europe of privacy for the United States, given its activity and the huge influence, frankly, that California has well outside the state. It really does seem to set a baseline for many of the practices and is folled. But
well,
as
also,
you said, yes.
And this isn't just California legislation, because it regulates the privacy bills regulate anyone who collects data from a California resident. So in essence, it's national legislation.
In its impact, I would argue, yes, you're absolutely right. It has a national, indeed, even a global impact. If an international company is aiming to serve or interact with people in California, hence my using the term Europe of privacy. In many ways, Europe tries to regulate privacy in a similar fashion by saying that any company, especially online companies that aim to interact with European residents or European citizens, would also be covered. Similar kinds of approaches here, and it's quite consequential if you're a company that's online and using using online medium to interact with consumers. So as you said, the governor signed the Do Not Track bill on September the 27th, and it really he was signing a bill that passed unanimously, really, with 78-0 in the Assembly and 37-0 in the Senate. And this particular bill amends something called the California Online Privacy Protection Act, and really requires online companies to disclose whether collecting information about an individual's online activities in a way that goes across time and different websites when that consumer uses the individual company's website. So basically, they're saying, you've got to say whether or not you track, and you've got to say how you respond to a web browser's do not track signals if an individual consumer is wanting to exercise that kind of choice. It says, don't track me across websites. Now, that's easy to say, but there are some really significant practical questions about what if you're writing a website, what that really means. And in one case, one very practical question is, well, what is a third party? What does that mean in the context of maybe, one company might have subsidiaries or affiliates? Are they third parties, or are they just part of my organization? And really, the most important question, I think, is what does do not track really mean? That's a question that has been the subject of really vigorous debates in a do not track working group that has been covered a lot by the media, that has really had a hard time defining that, and particularly in the World Wide Web Consortium working group that's focused on do not track, there has not yet been a fixed definition of what tracking really means. So there's some definitional issues for sure as companies work on figuring out how to comply with this law. And one saving grace, however, is that there's a interesting provision in the new law that gives companies a 30-day grace period to fix something if the Attorney General of California notifies them that they are not compliant in some way. So if you take some good measure, good faith measure to do something. Let's say you post a link to a program that talks about how you offer choice to consumers, et cetera, but you've got some gaps in the eyes of the Attorney General. You've got 30 days to address any deficiencies once you're notified. So that's an interesting addition to this bill, and one that bears knowing about, just because it's a little bit vague at the moment, not quite clear what the scope is, and that gives you some breathing room potentially.
And it's kind of like I guess it's a two bites at the apple approach, and that's available under existing laws. I remember when the Attorney General went after Delta Airlines, because she sent a notice and they had 30 days to correct, and they didn't correct. And I thought, how can you screw up such a simple thing? But what impact, if any, does this bill becoming law have on the broader do not track debate? Or is it just California just trying to choose sides in the whole debate between Mozilla and the ad community as to what should be the proper approach in terms of the settings for browsers?
I actually think it's too early to tell what effect this will have. It'll be important to see how some of the major websites choose to comply with it, and how the state itself, the Attorney General, and other influential observers act in response. So, if a state chooses to participate in one of the online programs that talks through or discloses how the website participates and offers ad choices to an individual, if that kind of a link and that kind of disclosure is sufficient, then that may not affect the national debate. But we'll see. I think it's too early to tell.
You operate in Hogan's Washington office, which many years ago I used to look into every day from my window, and the do not track debate. Is that really getting any traction these days in Washington, or is that just not really going anywhere?
Again, it's hard to say. There's been a huge effort, famously, I think, led until recently by Professor Peter Swire, who recently left, and they've gotten some new co-chairs in the W3C working group. But it does seem to have they're ground to a very, very slow crawl. But personally, I think this is one of those issues that will not go away. It's been defined in the national level. Federal Trade Commission has put forward for years now some pretty compelling thoughts on the individuals, an expectation that individuals will have some ability to choose and to not have information about their evidence across unrelated websites be monitored. We'll see.
And do you think there's any chance of a legal challenge just on the vagueness, or we're going to see this rolled out? And this is one of the ones that go into 2013, correct?
This new California legislation. I think again it's too early to tell. I think there are some interesting potential here, but again, I think if you look at the language of this and look at ways to signal compliance, there may be a way to do this in a practical way. But no doubt, California has had a history of, particularly with the activity of the Attorney General in the state, of setting a standard. I mean, look at what Ms. Harris did with the mobile apps guidance, and the fact that California's issuance of app privacy guidance was actually even different from what the Federal Trade Commission at the national level issued, being operators of developers of app platforms. Platform providers at a little bit of a tension with the federal guidance. It's evident of California really having a point of view and an approach that is its own. And so if you're operating nationally, when we do an analysis for our clients, we do a national analysis, and then we typically do a special one for California because of the number of both laws as well as important sets of guidance that have come out of the state.
And one thing that's interesting is that Ms. Harris has really made it a big effort for enforcement. She has set up a special enforcement unit for privacy, and then at the end of last year, or beginning of this year, she released a report on data breaches, and which we'll be talking about a little bit, and saying that that's going to be an enforcement priority as well. So this isn't something that you can look at lightly when you have someone who's being very aggressive in a key area of the California economy and the national economy.
I think that's California is. Here's an anecdote. I was at a dinner last night, and I was seated next to the state attorney general of a different state, not California. And this person we were chatting about the influence of California, and this individual said, if California and New York's AG really choose to move on an issue, to invest in an issue, they get that issue addressed. They will move the nation. And we were talking about this in the context, broad sense of issues, but it absolutely is the case for California that they have chosen to invest and have had already an impact. Now, you may know, and your listeners know, that at the national level, the state attorneys general have chosen privacy as a top issue. Perhaps you've covered that before, or others have read that, for example, earlier this year at the National Association of Attorneys General meeting in the Washington area and in Maryland, that the entire conference recently, a handful of months ago, focused on data privacy, and the attorneys general are comparing notes. They are coordinating their at least their approach and their sharing of information, and are equipping each other with tools. And the creation of a special enforcement unit and these kinds of assets is definitely something that I would expect to be followed and mirrored by those states that either have the resources now or may, with time, given the focus generally on identity theft and consumer protection, may eventually get them. And so I would expect that to happen.
We actually had Doug Gansler, the Maryland Attorney General, who's head of the Association of Attorney Generals, on our show last November, and he talked about his privacy initiative. But we're going to talk about that a little bit further. But first, we're going to take a short break, and when we come back, we're talking with Harriet Pearson about California and privacy.
Stay tuned for more of the Cyber Law and Business Report after this brief recess for our sponsors.
And events.
There are many things we would love to catch. Catching the final out of a baseball game.
And that's the ball game.
Reeling that big catch of the day. Or catching a ride home.
Taxi.
How about catching more attention like the biggest retail brands on earth? Introducing Catchy.com, where they sell short-branded attractive.com domain names. Use a short and catchy brand, just like Sony, Visa, and Nike for your next business venture. You can even rent to own for as low as $100 a month. Catch a big break for your business with Catchy.com.
I'm John Ball, and I'm one of the founders of Page One Power. Page One Power is a custom link building firm based in Boise, Idaho. We increase search rankings and web traffic for world-class brands and mom-and-pop shops all around the globe. Our link building strategies work because we focus on relevancy and quality, and we don't outsource anything. Our in-house staff of professional writers and researchers is the best in the industry. We're the link builders you've been looking for. Visit us today at pageonepower.com.
Oh yeah, my day is done. Time for happy hour.
You're already done for the day?
Yeah, because I use certifiedknowledge.org. Their PPC tools literally save me hours every day.
How do you keep on top of all of Google's new features?
Easy. With Certified Knowledge, their interactive learning modules keep me up to date. And if there's something I don't know, I can watch their video lessons without having to hunt around the Google Help files.
Great. I'm ready to expand my knowledge.
Hi, I'm Brett Geddes. I'm the only leader officially supported by Google to teach the advanced track of the AdWords Seminars for Success. I personally recommend CertifiedKnowledge.org as your one-stop shop for all your PPC needs.
Learn, optimize, connect. Be smart. Go to CertifiedKnowledge.org now.
Hold on to your white hat or black hat. WebmasterRadio.fm is ready to take you behind the backlinks. We're digging and scraping past the surface of everyday news and views of search engine marketing and dropping our proverbial anchor text on the important issues affecting the industry with our panel of search engine insiders. Behind the backlinks.
Tuesdays at 5 p.m. Eastern, 2 p.m. Pacific.
On demand, anytime, inside the Search Engine Optimization channel. Only on WebmasterRadio.fm.
The best gavel-to-gavel legal news and information on the net is right here. This is the Cyber Law and Business Report, only on WebmasterRadio.fm.
Okay, and we're back. So, Harry, yes, we as I mentioned, we talked to Doug Gansler last year on his initiatives, and are you seeing much in terms of progress and greater awareness, or more importantly, greater enforcement sense of other state attorney generals outside of California?
Definitely, I think the landscape here is quite active. I think I'm speaking to you today from Seattle, where just a little bit to the north of California, where where there is a collection of about 1,000 privacy professionals, privacy officers and lawyers, government officials from companies and institutions around the country. And It's one of multiple privacy-focused conferences that occur in the United States, and one of the reasons there is so much dialogue and there are so many more people involved in companies focused on data privacy and data protection in their companies is not only is there an operational need to protect information against greater threats of attack, cyber attack, or insiders, but there really is a much more active legal and enforcement landscape. And I think y'all just need to, we track for sure. We have a blog. Our practice does call hldataprotection.com, and the International Association of Privacy Professionals also has a blog, and we track almost on a daily basis new actions being filed and new guidance being provided. The most active government agency is the two most active, I would say, and influential. They are at the national level. Federal Trade Commission is one. Health and Human Services has emerged as the other because of the powers they have under HIPAA to act against organizations managing health information. But under state FCC acts and other statutes that allow for the state AGs to get active, we've certainly seen an up there.
No,
Maryland's a good example. I think Doug Ganser actually acted against McDonald's not too long ago for in the kid privacy issue. That's just an example.
Now, you're at the IAPP. It's not the annual conference. What is it they're having right now?
They have two major conferences each year, one in Washington and one in a rotating location. And so this one is what they call the Academy. And
that's right.
The Academy has very good focus on training the individuals in government and in business on the latest developments and how to embed privacy and data protection in companies.
And we've had Trevor on the show in the past, and that's they usually, the IAPP, for those who are looking into it, it's a great organization. Trevor, they always put together and bring together a great collection of people to present, and it's a great way to meet a lot of people in the field. And
it absolutely is. Absolutely is. And, I was there at the founding when there were about 15 of us, and I think he announced yesterday that the organization is at 14,000 now.
Wow. I mean, it's just amazing. I mean, he does all of this from, last week we had on our show the general counsel of ICANN, and I remember I was kidding him that it was hard for me to believe that the center of the Internet universe was in Marina Del Rey, of all places, and although it has since moved to Playa Vista. But similarly, it's kind of amusing that to a certain extent, the center of privacy, in a certain degree, is in York, Maine, where Trevor runs.
Actually, the headquarters outgrew York, Maine. Now is in New Hampshire.
Oh, it's in New Hampshire, Portsmouth, or where?
It's still. I forget the actual. I think Manchester, but I forget the actual city. But. New Hampshire is far away from California, but the issues do cross the country, and the second of the three pieces of legislation signed by the governor in the last couple of weeks was signed on at the very end of the month, September 27th.
Right.
And again, just like with the Do Not Track bill, the breach notification legislation passed with, I think, no decision at all, unanimous votes in Senate and Assembly. And what this one does is amends the definition of personal information to include a password or security question answer combined with a username or an email address. Just think about that for a second. A lot of the debates we have in the privacy field have to do with what kind of data is covered? What kind of data is subject to? What is PII is the big question. And it's a very significant question because when something is PII, then it triggers the application of law and guidance that has to do with managing it. And importantly, in the breach notification context, if you have an incident that reasonably can be thought of as compromising the information, in the context of California, there is no threshold of harm there under their statutes. So got an incident, and there you go. You have to notify an individual and the regulator about the incident. So what typically has been included in the PII is name and bank account, name and social security number. Those kinds of pieces of information that taken together would identify the individual and lead to identity theft. And health information has also been included under federal and California's law. This amendment explicitly says if I have my name, Mary Smith, let's say, combined with a security question and answer that says your first grade teacher, and the answer to that, or something that can be used to access an online account, that would a breach of that would then require a notification. Now, again, as there is with other types of PII in these breach notification rules, if that particular set of credentials was encrypted and it was compromised, if, let's say, cyber hackers hacked in and stole the credentials in the hope of compromising folks' account, but what the files they stole, the data they stole was encrypted, then there would not be a notification requirement. But there have been enough instances recently that have come to the attention of the California legislature that involved unencrypted credentials files that this amendment to the existing state breach notification law is intended to address that apparent gap in coverage. So it would address unencrypted credentials that are potentially compromised.
And this, how significant will this be on a compliance level? What does this mean to businesses?
So what I think it means to businesses, this new breach notification requirement, is if I were now the privacy officer or general counsel of a company interacting with California, or maybe not even just as a press, I would say, to my marketing and business and technical teams that are responsible for the creation of the authentication measures and the protection of that information, I ask them a couple of questions. I'd say, one, explain to me how these credentials are protected when they're in use and when they're stored. Is there encryption used? And describe to me how that works. And then I'd sit back and listen a little bit, and then I'd listen to those answers and look at the statute and figure out if I thought that we could be eligible for the encryption safe harbor under the new legislation. And if I didn't, I would challenge my colleagues to say to tell me why they could not encrypt the information. Because ideally, you'd want to just be comfortable knowing that the credentials are sufficiently protected using encryption so that you qualify under the safe harbor. If for any reason that they're not able to be encrypted, then I'd be striving to see that there's great security around them, because the process of notifying and going public with these incidents is a painful process for companies. I've worked a lot with organizations as they do that, and no company likes to go through it. And I think there are a couple of companies here that I think whose recent experiences with compromised credentials were very much in mind here, and I think LinkedIn was one of them. It involved credentials being compromised, and no one wants to go through that. So that's the practical report of the new law. Is take a look. How are you protecting your credentials? Do you need to implement encryption? How expensive will that be? And if it's not feasible, then put in place a program that minimizes or manages the risk of compromise.
Now, there's been some data on just the average cost per record of complying with data breach requirements is quite high. I mean, something like thousands of dollars per record. Does that sound about right?
I think it's all over the map. If you're talking about the average cost, if there is a breach of
if there is a breach, yeah. I mean,
that's actually not too bad. That's anywhere. It depends on who you ask, but I'll say anywhere from $100, maybe even $75 up to $300 plus per record. That's the Ponemon Institute does a survey, and they've got a number somewhere in that range, maybe $100 and something per record. But that's really the cost. If you have, let's say, a breach, if you're doing an online service and you have a breach involving 1,000 credentials, 10,000 credentials, those are small numbers actually. Multiply those by 100 or 200, you start to get into real money pretty fast. And if you're one of these major players and you've got 1 million, that's real money. That's real money. And that's why these breach notification laws are quite high profile and high concern. When I work with companies at the general counsel level and above, no one wants to go through this, primarily because of the reputation damage. No one wants to be seen as not having adequate protections around data relating to their customers, but also because, frankly, it can become expensive. Because we're talking about the potential for large numbers of records. But the cost of notifying and dealing with the aftermath of a breach per record is what it is. The other cost, I think, that's the cost companies will be considering is how much would it cost to encrypt this new type of information. Generally speaking, if companies find that having the legislature tell them what kind of technology measures to put in place to protect information is not usually such a good idea.
Right.
So this is everyone wants to do good here, and this is very well-intended legislation for sure. But the challenge sometimes is that encryption and encrypting data, it may not be the only technologically useful way manage the risk. And so companies will have to look and say, well, how much would it cost to encrypt this? And maybe there was a good reason why this wasn't encrypted, and there were other protections in place. But now that we have this new legal and reputational risk because of the requirement to notify, now maybe we're just going to have to do this, even though it may not be exactly the right thing to do at the moment. And it may divert budget from, another initiative that might have been more useful to protect against identity theft or even intellectual property theft or compromise or something else from being done. What is the effect of? There are always unintended effects to these kinds of bills, for sure.
And Attorney General Harris has said she will focus enforcement efforts, I believe, on breaches involving unencrypted data. Is that right?
Yes, I mean that is what she has said, and that would make sense, because if there is encrypted information, then there really is not an issue. There really is not a threat. So
now,
it's total sense to focus there.
We only have a little bit of time left, and we haven't talked about the Senator Steinberg's bill dealing with children's privacy and more or less implementing European concept of the right to be forgotten for children.
Yes, I would say this is a fascinating third piece of legislation that came out of California recently. Here, it was not unanimous. There were a number of no votes in Assembly. And there's some time. Apparently, this one does not take effect until January 1, 2015. So there's a little bit of time here to ponder and plan how to address it. Again, it amends the California Online Privacy Protection Act, and there are two major provisions here. One is this right to be forgotten provision or erasure provision. And really it says if you're a website operator and if you have actual knowledge that your website, your service is being used by minors, or that you're really directing your service at minors, you've got to allow those minors to request removal or to actually remove themselves content that they've posted. You've got to and also provide notice, post something that says to the minor, to the kid that, yep, you can do that, and tell them how to do that, and tell them if once they do that, if it doesn't quite, completely erase the content. Now, this is for visible display of the content. So think about, if my child is under 18 and has a Facebook account or some kind of an online account, that I've allowed them to have, or maybe I didn't even allow them to have, but they're smart enough to figure out how to do it. And they post pictures. They post stuff that is, youthful stuff. And that, in a few months, they think better of it, or they have had a discussion with me as their mom, and we all think better of it and say, I wish you hadn't done that, honey. That's not a good idea. And so let's go figure out how to get it off. That's really what this bill is all about. Is how do you get the information out of the public arena? That's what it requires. Now, practically speaking, this debate about how do you give someone, a consumer, that right to be forgotten has been raging in Europe for over a year now. Huge practical implications. Huge. How do you, if you're an online platform, if you're a social networking service, if you're a consumer-facing company and you're not a social network but you're just facing a consumer, how do you actually do this? And do you have to get rid of the information in your databases? Under this new law in California, no, you're not. You just have to get it off so that it's not individually identifying the minor. And if the minor doesn't follow the directions right, doesn't do it right, you're not responsible. But you do have to take these several steps. Now, these new requirements don't apply if you're required by other laws to retain the information, or if you paid the individual for the information. There are some, I think, reasonable exceptions here, but there's not a doubt that this new requirement is a step in that right to be forgotten requirement, and for a constituency, kids who, I think we all agree, out of all the types of individuals, kids under 18 are the type of constituency that deserves some additional protection, and that's why at the federal level we have the Children's Online Protection Act as well.
Well, I'm afraid we're running out of time, but I really want to thank you for your insights on each of these items of legislation. Very important, coming out of Sacramento, being signed by Governor Brown. Now, Harry, if people want to learn more about you or Hogan, what's the best way for them to do so?
As I said, we have a blog with almost daily updates on important developments in privacy and data protection. It's at hldataprotection.com. And we have, if you can look at hoganlevels.com, you'll find myself and my colleagues there.
It's a great blog. I do follow it, and hopefully we can have you back to talk about the Wyndham FTC case, because I think that's going to be fascinating. But I want to thank you very much for your time and say hi to everyone up in Seattle.
My pleasure. Thank you.
And it was a pleasure having the great discussion, and we definitely want to have her back to talk about the Wyndham case, because that's a very fascinating case. Basically, the FTC has regulated data breaches, and basically the FTC mantra is the fact that you have a data breach doesn't mean you'll get investigated. The fact that you have it doesn't mean that you won't. And the FTC has authority to regulate unfair or deceptive conduct in interstate commerce. And they've taken the position that having inadequate security under certain circumstances can be either unfair or deceptive. And so they've made a number of enforcement actions and consent decrees with all the internet giants, from Facebook to Twitter to Google, and then they came down to Wyndham Hotels. And Wyndham Hotels said, no, we don't think that's part of your authority under the FTC Act. We don't think you're allowed to, in essence, promulgate rules on what is appropriate data security standards. I don't think that's what Congress intended. And so there has been heavy briefing. The Chamber of Commerce has been intervening, and as well as some conservative groups, as well as some groups on the other side have come in, and so you have a very significant pitched battle in federal court in New Jersey, and there's going to be an oral argument in the fall on that. And it's going to be really interesting to see what happens, because that's going to be a very important outcome. And Harriet is part of is involved in some of that briefing. So hopefully we will be able to have Harriet back to talk about about that. There's another major development. There's another bill signed by Governor Brown that we just referred to briefly at the start of the show, and that was the passage of the revenge porn bill that was offered by California State Senator Anthony Cannella. And it's a partial victory in the area of revenge porn because it only covers some of revenge porn. And basically it applies to revenge porn that someone takes. So the perpetrator had to have taken the actual images or video, whatever footage it is that's at issue. And so it makes it unlawful to any person who photographs or records by any means the image of the intimate body part or parts of another person, identifiable person, under circumstances where the parties agree or understood that the image shall remain private, and the person subsequently distributes the image taken with the intent to cause serious emotional distress, and the depicted person suffers serious emotional distress. That is now a misdemeanor as of today. In California, this was passed as an emergency measure. That's the terminology used in Sacramento. So that is a bill that takes immediate effect. Normally, bills coming out of Sacramento take effect on January 1. So it's a big step forward. And as I mentioned on my blog post, that already the fact that it was on the governor's desk has spurred a great deal of debate and comment, and which is great. We do have a statement from the End Revenge Porn group. They're a campaign of the Cyber Civil Rights Initiative, and it's been issued by Holly Jacobs, who is one of the leading advocates for revenge porn legislation in Florida, and she's suffered seriously as a result of what has been distributed, the content that was distributed by her old boyfriend. And so she has issued a statement applauding the signing, and she says that law not only addresses images or recorded by other individuals, which means that it fails to cover self-shots, or what we commonly refer to as selfies. According to their own survey, up to 80% of victims belong to this unprotected category. In addition, the bill requires perpetrators to act with intent to cause serious emotional distress, which creates an additional and unnecessary burden of proof. Legislators narrowed the scope of the bill's reach after critics cited First Amendment concerns. Holly's group takes the position that the carefully crafted law banning revenge porn does not violate the First Amendment. And Ms. Jacobs said that in previous laws that prohibit harmful conduct such as stalking and harassment, of which revenge porn is often a form, have not been found to violate the First Amendment. Revenge porn is the posting of private material, not material of public concern, and has no First Amendment value, she says. She gave a great praise to Senator Anthony Cannella of Northern California, and saying that Senator Cannella was one of the first lawmakers to take action on this issue and to deliver any measure of success. We hope to continue working with him in the future to strengthen California's law. This issue will only get bigger, and the laws will catch up with technology when the public decides it has had enough of tragedy as a result of revenge porn. Our goal is to convince people that revenge porn is wrong today. Perpetrators convicted under SB 255 will face 6 months in jail and a $1,000 fine. California joins New Jersey on the list of states that have addressed revenge porn. But I think they do it differently than New Jersey, which it's actually a felony. But I think it's an important step forward. And you're seeing a lot online about it. You're seeing a lot of articles come out about it. And for example, we have comments such as by Emily Bazelon, whose father was a very distinguished federal judge, and she says, right, and the title of the article says it all. Why do we tolerate revenge porn? And she says revenge porn cannot be allowed to be a harm without a remedy. And University of Miami professor Marianne Franks, who's been very active in this issue, she's actually drafted a very sensible model bill that just really focuses on the core issue, consent. And as another article in Slate by Amanda Marcotte explains, that we look to consent can be given and consent can be taken away. Just because you consent, for example, she says, if a woman happily takes a naked selfie on her own accord, does that mean she is simply just leaving herself open to later exploitation? Just as we recognize that two people having had consensual sex doesn't mean later encounters are necessarily consensual, we should recognize that a picture offered as a consensual sexual gesture can later be turned into a tool to harass and abuse. And there should be penalties for that. And if I can just make one last point about this, since we had this show in July on this issue, and, I've mentioned it to a number of people, and often I get a response that's somewhat of a snicker. And when I brought it up at a reception with a state legislator, and there was some kind of stir about it. And, I think we're too often in this issue, we're blaming the victim. We're passing judgment on these people for how dare they have naked pictures taken of themselves. I mean, that's none of our business. But what we really should be focused on is that our citizens, these productive people, are being harmed, and in a way that that we have reasonable measures to address, and without violating the First Amendment in any way whatsoever. And so I applaud the steps taken in California, and I hope we go further than what we've done. And I think what Professor Franks has done is laudable, and I hope other states, as often is the case, follow California's model and even go further. And I invite you to check out the blog post on ilc/cyberreport.wordpress, and we'll talk about this further, I'm sure, as this goes along. But congratulations again to all those working hard on this issue. It's a big day and a big step forward. We'll be back after these messages. You're listening to Cyber Law and Business Report on Webmaster Radio.
Stay tuned for more of the Cyber Law and Business Report after this brief recess for our sponsors.
Ever wondered how you could have access to your own SEO expert, paid search specialist, or social media wizard? Looking for help with your affiliate, display media, or email marketing? Look no further than the folks at Fang Digital Marketing. Fang Digital specializes in both paid and organic search, social media, display, and mobile advertising solutions, and is staffed by industry veterans from Google, Yahoo, and one of the industry's most influential PPC experts. Fang Digital's award-winning staff stays on top of the latest in digital trends and offer tailored solutions so they can audit your progress and build a roadmap to your success. Learn more about their expanding range of full-service strategic marketing solutions at fangdigital.com. That's F-A-N-G digital.com.
If you're constantly struggling to find more customers, revenue, or hours in the day, Infusionsoft can help you have the business you've always wanted. For over 10 years, Infusionsoft has been helping business owners just like you find the financial freedom and peace of mind you've been searching for.
I'm Scott Martineau, co-founder of Infusionsoft. If you're struggling to find more customers, more revenue, or more hours in the day, Infusionsoft is the proven solution you're looking for. Infusionsoft, the only all-in-one sales and marketing software created specifically for small businesses.
Learn more at www.infusionsoft.com/radio.
Johnson, what's this Mantis I keep hearing about? Do we need to call an exterminator?
No, sir. Moby Mantis is our new SMS marketing tool.
SM what?
SMS, text messaging. Moby Mantis lets us communicate directly with our customers in real time. We can send promos, coupons. It even lets our customers market for us by sharing offers with their friends online. It's been great for business.
Sounds expensive.
Actually, I signed us up for an extended free trial. It hasn't cost us a dime.
Good work, Johnson. I guess the only thing we'll be exterminating is the competition.
To get your free extended trial of Moby Mantis, text radio to 21691. That's radio to 21691 for Moby Mantis.
We're rocking the world with LinkedIn. One show at a time. Join your fearless leaders, chat with other LinkedIn gurus, and answer your LinkedIn questions. Rock the world with LinkedIn. On demand, anytime, inside the Internet Marketing Channel. Only on webmasterradio.fm. The best gavel-to-gavel legal news and information on the net is right here. This is the Cyber Law and Business Report, only on webmasterradio.fm.
And we're back, and we only have a few minutes left. I just want to make a few notes. As you know, I'm fond of what happened today in history. And today actually is the birthday of Mohandas Gandhi and the anniversary of the swearing in of Justice Thurgood Marshall as the first Black Supreme Court Justice. Happy birthday to Annie Leibovitz and Sting, two other giants in their fields. But there's some tragedies I want to point out that often are very much overlooked in history. One is this day in 1937 is what is known as the Parsley Massacre. And there in the Dominican Republic, the dictator, Trujillo, decided to expel the Haitian migrant workers. And apparently, Haitians who mostly speak French cannot roll their R's, and so they could not pronounce the Spanish word for parsley. And so the legend is that they actually were stopping Haitians or suspected Haitians and asking them to say the word parsley. And if they said it wrong, they were executed. As many as 20,000 Haitian civilians were killed. And this was basically a genocide within our own hemisphere. And ultimately, FDR and the Haitian president forced the Dominican Republic to pay over $500,000 in reparations for this tragedy. But more recently, in 1968, only 10 days before the Mexico City Olympics, student protests in downtown Mexico City were greeted by snipers and police and the army, and as many ranges from 30 to 300 students and demonstrators were killed, and then it was quickly covered up because the Olympics were just about to start. And only recently has the government admitted that what happened, and is known as the Tlatelolco Massacre, or the Night at Tlatelolco, and is quite a tragedy that just never really has gotten the attention it deserves. So two serious events, tragic events in our hemisphere happening this day. There's actually a wonderful novel on the Parsley Massacre written by U.S. American author Edgewood Denticott called The Farming of Bones. And I encourage it to you all. But that's all we have time for, I believe, this week. And we're still open while the government may be closed. And so we look forward to joining you again with another edition of Cyber Law and Business Report. And we're definitely going to be following up on some issues in the future. One of them we were looking at is the emerging issue of Bitcoin. And we're hoping to get someone from Bitcoin on the show very soon. And that should be a very interesting topic. And also, I would notice that the New Media Expo is soliciting nominees for podcasting awards. And if you're listening and you enjoy our podcast, please take a look and consider us for the 9th Annual People's Podcast Awards. Nominations are now open. But that's all we have for now. Enjoyed having you, and thanks again to our guests. It was a pleasure talking with Harriet Pearson, and we'll be back next week from Santa Monica with more Cyber Law and Business Report. Court is adjourned. We'll see you next week.
This has been a presentation of WebmasterRadio.fm, the world's largest business-to-business radio and podcast network. We welcome you to sample past episodes of this program, as well as our complete library of programs, on demand or on the air via our 24/7 live audio stream at www.webmasterradio.fm. The opinions expressed on this program are those of the guests and hosts and do not necessarily reflect those of WebmasterRadio.fm's management or sponsors. Any rebroadcast or redistribution without authorized consent of WebmasterRadio.fm is prohibited.